All right.
All right.
Thank you. Back over to you.
So,
Sum up everything you've said.
Oh, God.
I was talking about dispositions and how they are so different from criminal sentencings because they are incredibly individualized. At every disposition hearing, there is a case plan report that is tailored to the individual child and that identifies specifically, here is what services this child needs, and also identifies tailored, like we don't have standard conditions of probation in juvenile court. We have tailored conditions of probation. We write the conditions of probation for each child's situation specifically. And that's really, from my perspective, the magic of juvenile court is the disposition process. It is so unlike criminal sentencing in that it is so focused on identifying needs and meeting those needs. And so I really wanted to highlight that. Post-disposition, if the youth is in custody, so most youth are not in custody post-disposition. Most youth go through disposition, most youth are put on probation, but they're not put in custody. And so, but if a youth is in custody, there's going to be regular permanency hearings, which are hearings to determine essentially, are we doing everything in our power as a state to get this kid out of custody and into a permanent living arrangement? And that's another thing that I think is really differentiates the juvenile system from the adult system, is there's a real focus on successful transitions. These permanency hearings are really focused on, okay, you are going to sort of emerge out of this as a young adult, and what are you emerging into? Have we as a state provided you with educational resources, access to housing resources, access to employment training, all of the things that we can do to try to set a kid up for success as they depart the juvenile justice system. There's also violation of probation hearings, out-of-state placement hearings, other types of hearings that happen after the case has essentially been closed. And that's another real difference between the criminal division and the juvenile division is at the criminal division, you get sentenced, and in most cases, that's the end of the story. There is no more sort of follow-up after that. In the juvenile court system, there is a lot of follow-up after the disposition. There's sort of constant check-ins to see, are we making the progress we thought we were going to make? And then ultimately, here's a case closure, either at the end of the probation term, or if the child has accomplished all of the goals that were set out for them, they might get an early discharge.
Yes, thank you. So I apologize. It goes back to number one and the steps of this. This is something that came up yesterday because of the charging decision. It sounds like there is a screening tool that is used, the YAZI. I'm wondering if you could speak to that, because I feel like that leads into if it's charged and goes into the juvenile division or can go to these other off-ramps. I don't know if you're going to be speaking to that in more detail.
I can answer that. So the YAZI is the screening tool we've been using in Vermont for at least 16 years, because it was there when I started. It's a very, I would say a very good tool in the sense that it is accurate. It's been normed in Vermont using Vermont statistics. And so it's, when we look at the results that the YAZI give, which the YAZI, just so that you know, it's a series of questions broken up into two sections. There's a preliminary section, which is about 35 questions, and then there's a complete YAZI, which adds another, I've forgotten, 40 more questions or so to that list. And it's based on actuarial data. So it's based on looking at cohorts of data and saying, okay, young people who have these characteristics committed offenses at such and such a rate. And so you basically run somebody through this list of questions and ask questions like, some of them are kind of subjective. They ask questions of your parents. They'll ask your parents things like, does your child usually follow the rules at home? They'll look at more objective things. How many police contacts has the child had? And all of that data is fed into a sort of mystery algorithm. This is a privately owned company, and they don't let us see their algorithm. But it's fed into a mystery algorithm that spits out a risk and needs level. It says this is someone who is high risk, high needs, low risk, low needs, or somewhere in between, moderate risk, low need, low risk, moderate need. And it does that in domains. It says, okay, you know, for this kid, the family domain is a real risk. And therefore, you're going to need to put some effort into stabilizing this kid's family. Like maybe everything else in this kid's life is actually stable and supportive, but when this kid's at home, they're subject to a really chaotic, really hectic environment that's destabilizing the rest of their behavior. And that's the kind of stuff that the YASI can identify, and that allows us to really tailor not just charging decisions, but also the disposition. The YASI is used at 2 stages. It's used, the preliminary screen is used at that charging decision, and then if you get to disposition, you do the full YASI, and your disposition is in large part based around what domains the YASI identifies as areas of strength or areas of need.
A piece that came up as a follow-up on this is that it is optional for youth that are entering the system. And so my question to you is, what is access? What does access look like? Do you feel like most youth are having the access they need or choosing that as an option? Who is giving it? Because it sounds like Barge does, but that's not until you get to the disposition or past the charging piece of it. So I'm just wondering, do youth have the access they need to YASI so then they could be eligible to go down these diversion paths?
In my experience, the answer is yes. We have certainly had occasions where there have been problems getting youth access to the YASI, but I would not say there's been any systemic problems. There's been individual cases where for one reason or another, some communication doesn't happen, and a kid is not given access to a YASI, and we're always able to correct that when we identify the problem. But in our experience, we're not having trouble getting kids the YASI. The reason that it's voluntary and not mandatory is because this is pre-charge. When it's offered pre-charge, you can't really require it of anyone because they haven't even been charged yet. So they are not subject to court orders yet. And it's more given as this would be a good idea because it may inform the prosecutor's charging decision. Whereas if they see no YASI at all, they're just gonna charge you in juvenile court. But if they see a good YASI, they might send you to diversion.
And is it your office that would offer it to the, who?
No,
That's what I'm not getting the answer of. Who is it that?
So I
You're
think,
trying very hard.
I know.
no, it's not.
And who pays for it? Is it
So the short answer on who pays for it is that it's paid for, I believe, by DCF. In terms of who provides it, that differs from county to county. They have contracted providers, and in a lot of counties, it is the Barge provider. I don't think it is the Barge provider in every single county. If it is, that's new. It used to be sometimes diversion board care programs that were doing it, and sometimes DCF itself that was providing the YASI screening. I've had clients go through it all different ways, with a DCF worker, with a Barge worker, and with court diversion workers.
But from the Defender General, you're feeling like attorneys they know who is it and can make sure their clients have access to it.
In the disposition context and in the youthful offender context, yes. In the pre-charge YASI, the answer is no, and the answer is because at that point, a kid doesn't even have a lawyer assigned, so we would have no idea. We don't even know that the child exists, much less the case and the YASI. So that's pre-assignment of counsel.
So who knows to get the YASI to the kid?
It's usually when the child is cited, they're given instructions that say, call this number and make an appointment to get a YASI. if I go to an arraignment and my client has not yet had a Yazi done, I say, okay, we're gonna get you a Yazi. And we take care of it within the next.
Yeah, I mean, mine was just really like who paid for it and if it, you know, the costs were expected to be covered by the family. It's prohibitive, but it sounds like DCF.
Representative Bishop and then Representative Arsenal.
Thank you. You referenced that the answers to the Yazi screening are put into the system and the algorithm goes to work. And that's sort of behind the curtain, if you will, proprietary. Is there any sort of, or has there been any sort of quality assessment, if you will, to determine whether the algorithm seems to be matching the needs and hopes for the system?
Yes, I mean, you'd have to talk to DCF to get the details, but part of what Vermont has done is, I think at several points since we've been using the Yazi, we've had the company that administers the Yazi norm it to Vermont, meaning sort of take a look at our numbers, take a look at, you know, what you are producing and see, is this actually giving us accurate results? You know, are the children that you identified as high risk actually turning out to be high risk? Are the children you identified as low risk turning out to be low risk? And that's been done, I know, at a couple of times since we have adopted the Yazi, and I think it's part of an ongoing. I think that's, they keep norming it as they generate more data, they keep fine tuning it.
I believe there was some reference in testimony yesterday to at least 2 times.
Yeah.
Great, thank you.
So apologies if I'm just not, if you've said this 3 times and I'm just not getting it, but I'm back to the Yazi thing and the options that it presents. And are some kids missing the opportunity to go to pre-charge diversion or, you know, through a restorative process because they might, you know, they're given a phone number at when they're cited, and then it sounds like incumbent upon them or a caregiver to initiate that process. So is it fair to say that some kids will miss that first opportunity to not become involved in the juvenile justice system formally?
This is based on my experience, not based on any sort of policy or law. In my experience, what happens is this, is if I walk into court with a new client who I'm just meeting for the first time, and they have not completed a Yazi, and I walk over to the prosecutor and I say, my kid never completed the Yazi, and it, you know, it's not their fault. It's any kid who's under 16, it requires their parents' involvement anyway to make arrangements and truck them around. And even the ones who are old enough to drive, most of them don't actually have cars. They can't arrange transportation on their own. I've never had a situation where I've gone to a prosecutor and said, hey, my kid never had a chance to take the Yazi, and had the prosecutor say, tough luck, I'm prosecuting because there's no Yazi here. Instead, what they've always said, every single time, they have said, okay, give me a Yazi. And I did. And they consider it, and they make a decision as to whether or not to divert or prosecute. And is it still an inconvenience? Does it mean that there are some kids who they have to go through an arraignment and a little bit more court process before they get that Yazi? Yes. Do I think that the outcomes are substantially different? No.
Okay. And there's also the option that the prosecutor has at the very beginning to send the case directly to a CJC or some other, right, to an alternate.
Yes.
Yeah.
And that's usually an option that, in my experience, prosecutors don't generally even entertain that option without a Yazi, except maybe for some really low-level offenses that, you know, you can tell by the affidavit are really more appropriate for a diversionary process. And then case closes at the end of probation unless the child is discharged early. So then, the next question was, what happens for someone under 17 charged with a violent felony not listed in 5204A or 5201C3? And the process here, I'm not going to go into great detail because It's exactly the same as the other process, with the addition of what I highlighted in yellow, which is because if somebody is 16 or 17 years old, and if they're charged with a felony, any felony, this asks a question about violent felonies, but this is not limited to violent felonies. We treat any felony this way. So if a 16 or 17-year-old is charged with any felony, then after that preliminary hearing, the prosecutor may choose to file a motion to transfer the case to the criminal division. And then there would be, and I say may, but there's an exception to that. And that is for the offenses listed in 5204 B2A Romanet 1. And those ones, they have to have a transfer hearing, whether the prosecutor requests a transfer hearing or not. So those are the offenses of defacing a serial number on a firearm, straw purchase of a firearm, and I think just human trafficking. So those ones, there must be a transfer hearing regardless of what the prosecutor wants. Everything else, all other felonies, it's prosecutorial discretion. They can move to transfer, or they can let it sit in juvenile court. If they move to transfer, there's a transfer hearing where the state has to show by a preponderance of the evidence that tips the scale by even a feather's weight, that public safety and the interests of the community would not be served if the child was treated in the juvenile court. Now, I'm going to skip through these ones pretty quickly because what happens for someone who's 18 who's charged with a misdemeanor is exactly the same as what happens with someone who's 17 or 16 who's charged with a misdemeanor, except for one thing that I forgot to put on the slide and I should have. And that is this. If you go all the way back to slide 1, one of the things that I put in here in each one of these boxes is the age of supervision, which is different than the age of jurisdiction. That's the age that DCF is allowed to supervise you until. And so if you are 16 or 17, DCF is allowed to supervise you for a felony up until the age of 19 and a half. If you are 18 years old at the time that you commit a felony, then DCF is allowed to supervise you until the age of 20 and a half. So it's one additional year of supervision for one additional year of age, but that's the only difference between a 17-year-old and an 18-year-old charged with a misdemeanor. And that's also the same difference for a 17 and an 18-year-old charged with a violent felony not listed in those sections. Again, it is exactly the same scenario with the exception that DCF has one more year of supervision available.
So a practical question, as far as if the 18-year-old violates probation and they need to be held, they could be held in an adult prison. Does that happen? Does that change things at all? Do you see that happening? That's, I don't know if I'd call it flexibility or there's not a prohibition for that person to be held.
There is an 18-year-old who's charged as a delinquent can't be held in an adult facility for violating their probation. An 18-year-old charged as a youthful offender can be held in an adult facility for violating their probation. An 18-year-old charged as an adult can be held as in an adult facility.
So it does matter in how they're charged.
Oh, absolutely.
Because I guess I asked that of somebody yesterday, and that's not the answer I received. It was the age, it wasn't how they were charged.
No, it absolutely matters. You can't write a DOC minimus from juvenile court. You can't send a juvenile.
Which is what?
Minimus is a document essentially ordering or defining the terms under which the state takes custody of a person for imprisonment in a criminal jail.
Okay. Yeah, that's a good one.
Just following up, so is the reason, see if I actually understand what's going on, is the reason that a 18-year-old who's a youthful offender who violates probation could be held is because DOC is the agency who's overseeing the probation, like they're the, no.
It's not even that, it's just that youthful offender is an adult status. You can only be a youthful offender if you are in adult court qualifying for adult court treatment. And at the end of youthful offender status, if you screw up, you get an adult court sentencing. So you are entitled to the rights of adult court, and you're entitled to all of the, what may be seen as negative aspects of adult court, which include being locked up in adult facilities. And so it's youthful offender status. I have a slide on it later. It's very much a high stakes, high reward, adult deferred adjudication status. It's not a juvenile court status. Juvenile court, one of the features of juvenile court is that it is entirely separate from the criminal court system. Nothing you do in juvenile court can land you in the criminal court or can land you in a DOC facility. It's very self-contained. That's not true when you reach youthful offender. Youthful offender is more like an adult status that uses the juvenile court as a venue to provide confidentiality and juvenile appropriate services. But it's still really an adult proceeding with adult consequences at the end and adult rights attaching throughout the proceeding.
Let me ask one follow-up question. Is it because of federal law or our law that an 18-year-old as a delinquent can't be held in an adult prison?
That is federal law and our law. Both laws feed into that. So there's a federal law called the Prison Rape Elimination Act, which says that whatever your state defines as a child can't be held in sight or sound contact with adult inmates in an adult facility without jumping through a particularly difficult set of hoops. There's also just in Vermont law, we don't have anything in the juvenile court statutes that would allow a juvenile court judge to issue any order that would send a child into the criminal court system in any way. So I would say it's both.
Okay, all right, thanks.
The next question was about the capacity of rehabilitative programs. And there's a lot to say about that because it's sort of a broad question. And that's because there's so many services that are considered rehabilitative programs. I mean, from my perspective, schooling, education is rehabilitative programming for my clients. If I can do something as simple as take a client who's struggling in school, not attending school, not engaging in school, and get them onto a successful track in school, I consider that rehabilitative. So it is a broad question. I will say that generally, the experience of our attorneys is we're not having problems getting services in the community. So our clients that need adolescent mental health treatment is a little dicey. That's one where I would say we usually get what we need, but we often have to hunt around to find it. But in terms of evaluations, in terms of adolescent substance use treatment has gotten a lot better in the last few years. Being able to get basic, essentially therapy and counseling for kids that need that sort of, just a sort of low-level mental health intervention, that's worked great. Things get trickier as you move up the continuum of need. We have long delays getting kids into more specialized programs. That's really where we have kids who need something residential, where they have an issue that needs to be treated in a residential setting. The residential programs have not yet recovered from the pandemic in the way that we would hope. During the pandemic, residential programs were closing entirely, and the ones that stayed open were cutting the number of beds they had dramatically, and it was largely due to staffing. They all have licensing requirements that require X number of staff per bed, and when they don't have the staff, that means they have to close beds. And they have not recovered from that after the pandemic. So we have programs that used to have, capacities of 20 kids, 30 kids that are currently operating and only taking in 10 or 15 kids. And that is really important because those what happens at that sort of intermediate tier, when you're above the sort of community level of treatment, but you're below the sort of highest level of intervention, is so important because it drives everything that happens at the highest level of intervention. You know, as the attorney who represented kids at Woodside, one of the patterns that we saw all the time at Woodside, the most depressing thing you'd see would be an administrative discharge hearing where everybody would agree. DCF administration, Woodside staff, clinicians, the attorneys, everybody would agree that the kid was ready to leave Woodside. They had done well, their behavior had improved, and they were achieving what they needed to achieve, and they weren't gonna get anything more out of the programming that was offered there. But there would be no bed available for them to go to, and they would stay at Woodside for additional weeks, additional months, and eventually they would decompensate. And eventually they would no longer be in a situation where they were ready to step down from that high-level program. And so from our perspective, one of the biggest crises in the juvenile justice system is not what's happening at the top end, secure treatment and placement in locked facilities, and it's not what's happening at the bottom end where most people receive their treatment in the community. It's that middle tier that we have the greatest concern about, because has everything to do with whether kids are successful and manage to sort of step down into community-based treatment, or whether they're unsuccessful and wind up stepping up into really expensive, really invasive, locked, secure treatment that removes kids from their families, from their schools, from their communities. Sometimes is necessary, but we try to avoid that. And I just wanted to add this as sort of a tag on the end, because there's been a lot of questions about Red Clover. It just opened 2 months ago. And I just want to say that our experience with Red Clover has been overwhelmingly positive. I do want to say the building, it's a crappy old building. It's not a good building. Other than the building, the program has been really excellent to work with, really excellent for our clients, and really, I think, has a very appropriate focus on safety and security and identifying when they need to, when do you need to be in this really secure environment, and when are they ready to move out, and getting them out as quickly as they can when they're ready to move out, which from our perspective is the most important thing.
Yes, Representative Arsenal.
But go ahead.
Oh, okay, thank you.
Oh, sorry.
No, that's okay. Trying to figure out exactly how to ask this question. So, one of the things that you've highlighted is that need for that medium level, and I think we hear that over and over again, not just in juvenile justice, but in mental health and in other disability services and services for older Vermonters as well. And so, thank you. I mean, it's an underlying fact that we need to pay more attention to that. Substance use services as well. That same sort of middle level of, the community-based stuff is going okay, pretty good access. The high-level stuff, people rush to develop that and, put a lot of money into it. And then that medium level. So yesterday we heard from a witness referred to secure settings for juveniles as incarcerative settings, and referred to it essentially as incarceration. And I guess I'm trying to get a sense, because what I see in the words and hear you say is that you've had some good experiences for your clients in terms of the rehabilitation and sort of like thinking about what their future might be in a different way in some of those settings. And do you view them as a necessary element of a complete continuum of care, or do you think that I guess that's just the question. Do you view them as an element of that?
Absolutely. I mean, I will say, as someone who, before I did this work, I was a teacher, and for a while I was also a behavioral interventionist for the Howard Center. And so I have some experience working with this population of kids. And from my perspective, we do have kids who get into states of crisis that cannot be safely de-escalated in a non-secure setting. I think there's a lot of debate about, it's legitimate, about do we need non-secure settings to extend beyond crisis de-escalation. That's something that's very much, I think, a legitimate area of debate. It's being debated around the country right now, but I don't think there's a lot of debate that there are, especially for teenagers who are large, who are physically difficult to safely manage. There are states of crisis that require a secure setting for de-escalation. As far as do we need to be providing long-term secure treatment, in my opinion, I've seen the cases where I think long-term secure treatment is beneficial. I think they're few and far between, and I think most everybody agrees with that. I think we dispute sometimes how few and far between they are, but I think, there are cases where I think I've had clients who have been served better in a secure treatment facility than they would have been in a non-secure treatment facility. I think I've had clients who ping-pong back and forth between, every time they hit a non-secure facility, they've blown out of it and landed back in a secure facility. And that, constant transition is not therapeutically valuable for anybody. You need some stability. I hate it when the only place we can create stability is in a locked system. But if it's all we've got, if that's the only way we can create stability, then that's what we got to do in order to provide the treatment. Because you can't provide effective treatment to kids who are just bouncing around the system.
Thank you.
I just want to make sure that, check my understanding, so do you count Red Clover as one of those mid-level? But that's still higher level.
Red Clover is a locked facility. You go in through essentially a sally port. It is surrounded by fencing. There is no access to non-secure areas by the residents there. And so that's not even from my perspective, by definition, that's a secure facility. It's a secure facility that is providing great educational services and mental health services that are in some cases better than what's being provided at the less secure tiers of treatment.
Right. But officially it's a short, it's a crisis stabilization.
I don't think anybody's described it as that. I think people have described it as short-term. I kind of reject the short-term, long-term distinction. When I worked at Woodside, they had a short-term wing that was full of kids who had been there longer than the kids who were in the long-term wing. And they had kids in the long-term wing who were being treated more like detentioners in the short-term wing. It didn't really make sense. So I've never really, that short-term, long-term distinction is one that I started out trying to use, but I abandoned pretty quickly in my practice.
Well, I don't mean to dwell on this, but I don't feel like I have a good understanding then of what what this middle level is that we're talking about. And maybe this is it's more human services, but just to understand what we should be advocating for.
So, sort of the ones that are used really commonly in Vermont would be like Vermont School for Girls in Bennington is a Beckett residential program. Then there's 204 and 206 Depot Street that are also in Bennington. Those are sort of short-term behavioral health stabilization, but not locked facilities. Those ones are actually what I would call semi-secure. They have time delays on the doors. So if you try to run from Depot Street, you hit the door and an alarm goes off for 30 seconds before the door opens up, so it gives staff time to come and get you. But technically it's not a locked facility. The programs that are run by Laraway up in Lamoille County and the Washington County Mental Health group homes and micro residential facilities, some of the programs that are and have been run by Spectrum over the years. It's that sort of what we would call group homes, congregate care facilities, residential treatment centers, all of those I would consider to be that middle tier. Anything where the doors don't lock behind you when you walk in.
Thank you.
I think you got logged off.
Yeah, I think I did too.
But at least I think we're still being heard.
Mine's back then.
Tell me now.
Sorry, I don't know why it logged me off.
30 seconds.
You're set to share again.
Okay, is my screen share? There we go. So, moving on to the next one. What happens if a juvenile is not meeting conditions? This is a really broad question because there are 3 different types of conditions off the top of my head that a child might not be meeting. And it's sort of a different process for each. So, to begin with, conditions of release. At the beginning of a case, at that arraignment, that preliminary hearing, judges often set conditions of release. I would say in most cases, judges set conditions of release. These are different than conditions of probation. They're not part of the disposition. They're not based on, here's what your needs are. They're based on, what do we need to do in order to keep you and the community safe until we reach the point where we figure out what your needs are and identify the services. And so the court can set conditions of release, and if a child violates those conditions of release, they may be charged with a whole new crime. They may be taken into DCF custody. So most, like I said, the vast majority of young people are released into their family's custody. But if they are committing repeated violations of conditions of release, that would be grounds for the state to come in and say, you know what, we want this kid to come into state custody. We don't want this kid to remain in their home. So that's, another option that a judge would have is to place the kid in state custody. And then sort of the highest option would be if the kid is continuing to commit violations of conditions of release, then the judge can send the kid to Red Clover. Courts have the authority in the pretrial phase of a case to simply order a child into Red Clover, Vermont, secure detention.
So very different than the criminal justice system where you can't detain somebody just because they're violating conditions of release, right?
It is different than, yes, it is easier because in the juvenile justice system, taking custody of a child is a very different situation than custody of an adult. And this is actually one of the things that came up a bit in yesterday's testimony from DCF in a way that was maybe not explained super clearly, but when DCF takes custody, they take custody as a parent, as a guardian. They take full custody. And that's actually really different than in other states. In other states, delinquency custody is treated the same as corrections custody. So when DOC takes custody of somebody, they don't take parental custody. They're not in charge of that person's healthcare decisions or their educational decisions or their religious decisions or anything like that. They just take physical custody. When DCF takes custody, they take full custody. They are in charge of medical decisions, religious decisions, educational decisions, all of that. It's not just simply having physical custody of the child. And so what that means is DCF has the ability to, when they have a kid in custody, to place that child in different placements just as a matter of discretion. So just like as a parent, if I wanted to take my child, if my child was misbehaving, which neither of them are, they could, they're 13 and they're 17 and 20, so there's definitely that potential. If they were misbehaving, not the 20-year-old because she's an adult, but the 17-year-old, I could say, you know what, we are putting you in a program for misbehaving children. Or I could say, you know what, you really need to be away from the group of friends that you're around right now, and I'm gonna send you to live with your grandma for a few months. And these are all the same kinds of things that DCF can do when DCF has custody. They can do all that same stuff. They can say, you know what, we think things are really unstable and are destabilizing you at home, so we're gonna put you with family, with your extended family. Or they can say, we're gonna put you in foster care. Or they can say, we're gonna put you in a treatment program. They have a lot of control.
So just real quick, so DCF has to take custody before they would make the step of detention?
Yes, but that is often a simple, if a child is violating their conditions of release, and DCF goes to court and requests custody in a 5291 order, which is an order placing a child in a secure program, it's a one hearing event. They show up and say, here's what we want and why we want it. Violating these conditions, there's a brief hearing, and if the judge orders it, then the child is in DCF custody and placed at Red Clover.
And not to put too fine a point on it, but that shows that there's some accountability for that individual, for that juvenile pre-merits hearing and such.
Yeah, definitely. It's, pre-merits, we have a lot of kids who are either detained or removed from their home in some way or another pre-merits.
Marshall, can I just,
yes.
So one of the things that our committee has heard about over the last couple of years, well, honestly, since Woodside closed, is the use of DCF staff, social workers, caseworkers, and honestly, lots of different people, to I don't know what to call it, to sit with, to staff up in hotel rooms, in offices around the state and stuff like that. What are you seeing from your client's perspective about that? Are you seeing the continued use of that? Has that diminished some?
That has diminished tremendously. In fact, it's not as if I get a report every time it happens, but I certainly hear about it most of the times that it happens, because we don't like it any more than DCF likes it. From our perspective, it's putting our clients in danger.
Right.
It's really an inappropriate setting for, it's usually used for clients who are in crisis. That's why it's being used, and it's almost the least appropriate setting for a client in crisis, is to be alone in a really sort of non-therapeutic space with somebody who's really there only to keep you safe, not to provide any sort of therapeutic or de-escalatory type of services. And it's not safe for the DCF staff. It's not safe for anybody. It is something that I'm horrified that we've ever had to employ, and I haven't heard about it in a little while, and I hope that we never hear about it again.
Thank you.
So conditions of probation are separate. This is what happens after disposition. So at disposition, in almost every case, a judge is going to put a child on some conditions of probation. And there's a bunch of different ways that violations of conditions of probation get addressed. First of all, DCF works with kids on minor violations. It's not like every time, because these violations, conditions for children are pretty extensive, and we kind of even accept the fact that they're gonna violate some of the conditions. One of the regular conditions is obey the rules imposed by your parents, right? Of course, no child is gonna comply with that condition perfectly. And that's why really the first line for those minor violations is DCF working with the child. So if somebody's parents call up and say, my kid's not listening to me, come and deal with this, DCF will step in and say, look, you really have to follow the rules at home or you're gonna get in a lot of trouble. Let's work with you to see, why did this happen? What can we do? And they might impose a graduated sanction. something small. They might say, you know what, for the next week, you're gonna have a curfew where you didn't have a curfew before. Or for the next week, your curfew was 9 o'clock, but we're gonna shrink it down to 6 o'clock. Because, you know, you're getting a little bit out of control and we wanna give you some structure here. So that's the kind of informal graduated sanction process that DCF often starts with for minor violations. If the violation is more serious, it's charged in court. And in court, there's a lot of different things the judge can do if they find that probation's been violated. They can impose new probation conditions. So for example, if I have a client who violates their probation by using illegal drugs and because they tested positive on a urinalysis, and we have a hearing and my client is found to have violated, judge might be a really typical response to say, you know what, since we've got this problem with you going out and doing stuff after school, your condition is good. You're gonna have a new condition, which is you have a 4 p.m. curfew. You have to go straight home after school. You can't be out on the streets after school. Simple response. It might be more serious than that. It might be to add a condition that says you have to engage in substance abuse treatment. It might be to extend the term of probation so that the youth is on probation longer. It might be to change custody. If the kid was at home and violating their conditions of probation, they might be shifted into DCF custody, placed in a foster home, placed in a residential placement, or placed in a secure treatment facility like Red Clover. And yeah, so that's the responses to violations of probation. And then there's violations of institutional rules. Every youth is in some kind of an institution. They are in school. They are in a treatment facility. They are in community-based treatments. And if you violate the rules at those places, that can change. It can be a violation of probation because usually there is a condition of probation that says follow the rules at your placement. It can also be something that gets you not violated in any way, but kicked out of a placement. And so it can result in a change of placement that might be a really negative experience or a positive experience, depending. So that's really sort of the conditions question. I'll try to keep moving, being aware of the time.
So we're actually gonna take a 10-minute break right now.
Okay.
Just to let people stretch, and then we'll finish up with you after that. But
I have a 10:30, in order to make the technology work with Karen, I have to start at 10:30.
okay, so we'll take a 10-minute break, we'll go to you, and then we'll come back to you for your last slide. I think this is a good kind of break.
Thank you.
Is that okay? Will you be able to stick with us?
Absolutely.
All right, so we'll be back at 10:30 so it's an 8-minute break. Welcome back. Over to you, Judge Davenport and Karen Bastine.
Well, let me start, and then I'm going to turn it over to Karen. We're here. Karen Bastine and I are both here on behalf of the Vermont Council for Equitable Youth Justice. Some of you who have been here a while may remember that you all changed our governing statute, and we're going to talk about a little bit what we do, and then we're going to address some of the questions that you asked. But just by way of background, I am, I'm a retired Superior Court judge. I was also at one point in time way back in the 80s, a member of the legislature. And I retired in 2015 and have been a member of this Council for Equitable Youth Justice since that time. And I'll turn it over to Karen to introduce herself and I just do have one comment about our slide presentation. You will notice that the colors that we used for our slide presentation are identical to Marshall Paul's, blue and white. And all I can say is I don't know how that happened, other than it's January and, there's snow and there's sometimes blue sky. Anyway. And so Karen?
Yep. Good morning, everyone. So I'm Karen Bastine, and I'm honored to serve as the chair of the Council for Equitable Youth Justice. I have been on the council since 2021, and I would just share that I have many, many years of having worked with the council before that. Some of you may remember me from a previous role when I was working in the commissioner's office as Ken Schatz's senior advisor. And I was one of the co-authors of the report that we submitted to the legislature in 2019 regarding the implementation of Act 201. So that's who I am, and I'm hoping that I'm able to share my screen right now. So let's see how this goes. Okay, is
Moment of quiet.
everybody able to see my screen? And it's
Yes.
just showing the
Yes, we are.
slides? Okay, I think I can see myself in the camera. Okay, so this is who we are, and I'm just going to give you a little overview of a little bit more of an overview of the council. So the Council for Equitable Youth Justice is Vermont's advisory group for juvenile justice and delinquency prevention, as is required by the Federal Juvenile Justice and Delinquency Prevention Act, as well as the Juvenile Justice Reform Act. And fun note is that the Juvenile Justice and Delinquency Prevention Act turned 50 this year. And so that was an exciting year for us with respect to juvenile justice, and much to celebrate in terms of the great gains that we have made for children in the system. The Council for Equitable Youth Justice has 21 members who are all appointed by the governor and then confirmed by the Senate. We are all volunteers. And the statute requires that we have specific representatives, including youth, victim advocates, law enforcement, nonprofits, and more. We are also attached to the Department for Children and Families for planning and administrative functions. So what we do is we support DCF's compliance monitoring with respect to the 4 core requirements of the JJRA, which is something I'll show you on the next slide. We also provide grants from Vermont's annual allocation of the funds that we receive from the Department of Justice. And these projects relate to juvenile justice and the prevention of juvenile delinquency. We also support the implementation of Act 201 and juvenile justice reform in Vermont. And we identify and reduce racial and ethnic disparities among youth who have contact with the juvenile justice system. So these are the 4 core requirements that I referenced on the last slide. And this is part of what we monitor with our partnership with DCF. So the 4 core requirements is the deinstitutionalization of status offenders. And so status offenses are things like truancy, and that would only apply to somebody who is a youth. We also monitor for the separation of juveniles from adult inmates, the removal of juveniles from adult jails and lockups, and addressing and monitoring racial and ethnic disparities. Judge Davenport?
Okay, so I am not going to try to address scenarios 1 through 4. Because I would basically be covering ground that, having listened to the testimony that you've received so far, you have already covered several times over. You've gotten, I have to say, the fire hose approach to juvenile justice in Vermont. It is an overwhelming, it is a complicated system, and you've gotten an overwhelming amount of information. I'm happy to answer questions, not only today, but at any time, really, that you have about the specifics, but I thought it would just be redundant, and you have limited time. So instead, I'm going to focus on 3 issues: data collection and accessibility. Secondly, programming for youth in the juvenile justice system. And then recidivism studies, which I don't think anybody has covered so far. So going to the next slide. What we know from the data, this looks at the number of case filings in Vermont from FY18, and I'm using the state fiscal year. So fiscal year 18 all the way to fiscal year 24. And so the second column has the numbers for delinquency and the third for youthful offenders. So what you'll see is that back in FY18, delinquencies were up around 800 and almost 900, and youthful offender was around 300. They started to come down in FY19, FY20. You begin to see a big drop. You may remember that yesterday in the testimony from DCF, they talked about the 500 youthful offender cases when jurisdiction got expanded up through 21. Yes, those were 500 applications for youthful offender. Those were not necessarily 500 who actually, in fact, it was considerably fewer than those that actually got the status once a hearing was held to determine whether or not they should be a youthful offender. But yes, there was an avalanche when the age limit was expanded. But then the next year, FY20, you start to see it come down. So before FY20, so at the time of FY21 is when July 1 is when FY21 started, and July 1, 2020, and that's when 18-year-olds came into the juvenile system. And you see the numbers on delinquency at FY21, they're 681, FY22, 573, FY23 up to 700, and FY24, my number is 679. I think some other people have a number of 700, but it's around that range. So one thing to be really cautious about, FY21, what else happened in FY21 and FY22? COVID, exactly. So numbers from those 2 years are just not very representative. I mean, filings kind of fell off a cliff, and then they got put back in. So it's taken really until FY23, I think, for the numbers to stabilize. Meanwhile, youthful offender continues to come down. I would say if 19-year-olds come into the system in April, you will see youthful offender drop again, or whenever 19-year-olds into the system, you will see youthful offender drop again, because cases that would be brought on behalf of a 19-year-old will now be delinquencies. So they won't need to ask for youthful offender status. So it's exactly what we saw when the 18-year-olds came in. You have the drop from 383 to 308, and then down to 256 last year.
We have a question here. Representative Stein.
With the 19-year-olds, I hope there's some stipulation that they still have to be in high school or secondary college and not a 19-year-old that's an adult. I would think there would be a stipulation, because that would be so wrong in so many ways. And I really don't see a lot of change in statistics. So
I think what you're addressing are policy issues that you all are in charge of. At the moment that those requirements are not there, but these are policy issues that you're in charge of.
So can I ask, while we're pause for a second, I have another question.
Sure.
As far as the youthful offender data, Do you have a breakdown of which ones were direct file versus motions? It'd be also great to understand how many motions are brought by defense counsel as opposed
to direct file.
Right.
I do not have that, although Judge Zone probably can get that, may be able to get that. I also think an important figure to look at is of those 256, how many actually were granted that status versus, I asked Marshall ballpark what he thought just this morning. He said he thinks it's around 50%, but again, it would be helpful to get that data, which brings me to the next slide.
Before you just go there, can I just ask a quick question? So while in legal terms, there's a difference between delinquency and youthful offender, I'm thinking sort of from my sort of DCF perspective. DCF has involvement with both of these groups.
Right.
And so when I look down, down through the years, I honestly don't see a appreciable difference in total number.
If you're adding the two together.
Right, when I look at the two together, and I realize they intervene and are involved at a different part of the process, and they may have different responsibilities depending upon whether it's a delinquency or a youthful offender. But I guess I'm trying to, we seem to have a lack of data on really what the outcome is.
Right.
Lots of stuff about filings, but not really a whole lot about outcome.
Yeah.
And so, our best thing to substitute for that is filings, since that's where we have the data. And there doesn't seem to be a lot of difference when you add them together.
Right. Well,
so
in terms,
consistent, I guess.
I would say this, and then I'm going to get to the next slide
Okay.
and address the outcome, the outcome question. I would just say this, that of the 679 delinquencies, those include ones that went to diversion that DCF never saw, don't have any part, right?
Mm-hmm.
Just as the YOs include youth who didn't get YO status, went back to criminal court, and other than preparing for the hearing about whether they should or shouldn't have YO status, DCF never saw them either. So to aggregate these and say this is their caseload, no.
No, I'm not saying
Yeah.
their case. I'm just trying to develop a sense of, I guess what we're continually hearing is that DCF doesn't have the capacity to address a change with 19-year-olds. And I'm trying to assess I'm trying to assess that period, I guess, what I would say. Yeah.
Okay, so maybe we could look at the next
thank you.
slide. So I tried to,
I'm sorry, before you jump, one other real quick question. That 679, for instance, does that include pre-charge diversions that never reached the court, or is that all?
no,
Okay.
that does not include, and that's important because the difference between, say, 700 and 679 may be that it's that many cases that you never saw at all because they went to pre-charge. They went to diversion pre-charge. They completed that diversion. A charge was never brought. And that data, and I'll get to it in a minute, but that data about pre-charge has been challenging. We know we got to up the numbers on diversion, both pre-charge diversion and post-charge diversion. But without, and I know you did a lot of work on this last year.
I'll note that.
It's critical that we know what the whole picture is.
Right, and Act 180 should,
Should help that, yeah. So if we could go to the next slide, this is, we have, in Vermont, we have a lot of juvenile justice data. We have court data, which includes, could include, the data is there in the system, number of filings, number of dispositions, for delinquency, youthful offender, youth in the criminal division. We know, at least if they're in the adult system, we would know whether it's a misdemeanor or felony. For some reason, they don't have that or didn't used to have that data, misdemeanor or felony, but if you know what the charges are, you kind of know, in the juvenile system, because we don't really do misdemeanor and felony in the juvenile system. We know the category or type of offense, and this is important. National Center for State Courts has a list, I can't remember, I think it's about 14 general types of offenses that are applied to all, that they look at the data from all states. So we have grouped together, they group types of offenses together, like the public order offenses. I think there are at least 20 or 30 of them, but they're all about public order, not doing what you're supposed to do. We have motor vehicle. They have motor vehicle offenses, domestic violence offenses, theft, robbery, assault, sex offense, arson, homicide. So those are groups. They're not broken down into felony and misdemeanor, but they are groups of offenses. And you can look at an age cohort, for example. You could look at all 19-year-olds and say, what types of offenses did they get? Did you see the most, the most number of charges? Somebody asked, I think yesterday, what about robbery, which you took off of the Big 12 list. When I did the analysis prior to the implementation of raise the age, when we raised the age for the 18-year-olds, I did the court data analysis for DCF. And I looked at types of charges, and that was a big piece of it. And I think there was one for 18 and 19-year-olds in adult court, there was only one, and it was 2 years worth of data, only one robbery charge and no robbery convictions. So you can find out, types of disposition, and this goes, Representative Wood, to your question. You can look at what cases were adjudicated, what cases were dismissed, what cases went off to diversion. If they went to diversion, was it successfully completed? And one thing to know about juvenile court is around a third of the cases that are brought in juvenile court get dismissed for various reasons. But they do not end up being an adjudication.
So before you go on, again, just to make clear, maybe the slide should say court diversion, because that, when we're talking about what
Court
data
diversion.
we can get
Right,
now.
it would be
it's
court
just
diversion.
Although we have data coming down.
Yeah.
Okay.
So court data is annual data. DCF and DOC, as you heard yesterday, have point in time data. So they can't tell you how many in a year, but they can tell you today, this is how many. And they can tell you, if you look at many days, you can kind of see what the fluctuation is and what stays consistent in terms of the numbers. And they know the number of youth in custody. You heard that yesterday. I heard 900 kids in custody. I went, what? Those were kids, all the kids in custody. I think they later said that only 87% of those are CHINS cases. So it's only 13% of that 900 that are related to delinquency. You can look at the number of youth YOs under supervision. DOC had that data, delinquent youth under supervision. And then the AG has data on diversion. The Attorney General's office does a wonderful annual report that they file every December 1st that's on your website. That data is broken down by county. And so there are good questions to be asked looking at that data. Why are some counties referring a significant percentage of delinquency cases to diversion, but others aren't? The range, when I looked at the FY24 report that was filed on the beginning of December, the range county by county went anywhere from almost 50% to 0%. What's going on in the 0%? What is going on? Maybe they're all going to pre-charge. Maybe that's just a really strong pre-charge program. I don't know. But they're good questions. I mean, I guess my point is that looking at data raises questions. that should be answered and helps us see where the gaps are in the system. So if we could go to the next slide. So I think what we need consensus on what data points are the most important. We need data that is easily accessible. So here's what's really important to see, and everybody, all these various different groups are looking at the same data. We need to see data that lets us see trends and gaps. And we need to see data that tells us about successes as well as failures. I mean, I think sometimes we focus on the kids, the cases that went south. And there are cases, based on my experience as a trial judge, there are cases that went south. They go south. There's no, I think it's just, we're human beings, right? Somebody makes one decision one day that leads to another bad decision, that leads to another bad decision. They go south. We're never going to eliminate those completely, but sometimes we spend an awful lot of time looking at those 3 or 4 cases that went south, and we are not looking at the success cases. And I think it's important. We need a rule against cherry picking. You know, people who say, look at this data, but not at this other data. And I think context is really important. I mean, as we just talked about, if you are shown data from FY21 and FY22, and you all ask the right question, this is COVID data. Why? We have to take that into account when we look at it. Karen, do you have anything to add on that?
I would like to just add that I think the committees have already discussed this in great detail, but we would just underscore the importance of data in helping to drive, system-related decisions. And, Title 33, 5101A speaks to this specifically. And as you heard from Judge Davenport, when we were looking at the system ahead of Act 201 implementation, as we were rolling out the plan for that, I think we would have just been shooting in the dark if we had not had the strong data dive that Judge Davenport had done, so that we could easily compare what was happening with 18 and 19-year-olds to their 16 and 17-year-old counterparts. It was critical in how we started to look at benchmarks for, pre-charge diversion, for court diversion, and also probation as well. So those were instrumental to us, I will just share. So I'm really encouraged by how much you all are focusing on how this can help you in decision-making.
And that's a great segue to the next slide, where I wanted to talk about 2 examples of how data can impact programming for youth. One of the things that jumped out at us when we did the data dive around the 18 and 19-year-olds and what would it mean to bring them into the juvenile court. We looked at types of offenses and looked at what kinds of offenses 18 and 19-year-olds were committing based on those groups that I told you about, the National Center for State Court groups. Where did we see, offenses that 18 and 19-year-olds were committing but weren't being committed by younger kids? And one of the areas was domestic violence. So domestic violence, it's not that 17 and under don't get charged with domestic violence. They do. But when they get charged with domestic violence, most of the time, it is an act against a family member. Mom, dad, uncle, an aunt. Kid gets mad and does something bad to them. That's a basis for a domestic violence charge. But the other type of domestic violence charges have to do with intimate partners. And those kinds of charges, intimate partner domestic violence, needless to say, 17 and under, you might get them occasionally with 17-year-olds, but rare. They're really rare. You get to 18 and 19-year-olds, you have kids that are living on their own, who have girlfriends, boyfriends, who are living with them, and you start to see the intimate partner those intimate partner charges. And the approach for intimate partner domestic violence is totally different, needless to say, to the approach that you would take to domestic violence that involved a mom or a dad or a sister, brother, whatever. And there was nothing, we couldn't find anything in term with then knowing that this was going to these offenses, because the first time domestic violence charge is a misdemeanor, it would go to the family division, it would stay in the family division. So we couldn't find anything in terms of the programming that we had in the state that was appropriate for that age group. So the Council for Equitable Youth Justice used some federal funds. We funded Bennington College to look to see, is there anything nationally that works for young people? And the answer was no. Most batterer intervention programs are based on what works for older people, 20, 25, 23, year olds, not 18 and 19-year-olds. And it turns out that what works for 18 and 19-year-olds, what really doesn't work for 18 and 19-year-olds is kind of the group therapy kind of thing that you think of that is typical with batterer intervention programs. Bring a group of folks who have been convicted of domestic violence and have them sit around and with in a therapeutic setting and talk about their, why and, all of that. 18 and 19-year-olds, that kind of therapeutic approach the research shows doesn't work very well. So we had Bennington College then look at all kinds of research and available data and say, if you were going to do a program, here are the things that should be in that program for 18 and for young people. And we then did a second grant to the Hartford Community Justice Center actually got the grant. And they have developed a program which is just now being opened up for referrals. And it's designed as a statewide program. A lot of it will be done by Zoom and other using it took 5 years. It took 5 years to do that. Some of this is not easy. I guess that's the one of the lessons. We don't know whether that program will work. We'll have to see. But it was worth the investment. And I know from work that I do on some other national organizations, this is an issue for a lot of states. A lot of states are struggling with this. The other thing that we did, we knew that we would need a really robust diversion program, which involved both pretrial and post-charge diversion. And we also funded a program for law enforcement training on restorative justice with the thought that if so often the decision on pretrial diversion is made by a law enforcement officer, right? They decide to recommend to the state's attorney, I picked up this kid, or I stopped this kid for doing something. I think this is a case. This kid doesn't need to be charged if we just send them to the pre-charge diversion program, but you got to get buy-in from law enforcement to do that. So we had the Community Justice Center in Chittenden develop a training program. It was not as successful as we would have liked. It was a 2-year project, not as successful as we would like, because what we found was law enforcement came to the training if they already bought into restorative justice, and they were happy to learn more. But for law enforcement that didn't really believe that restorative justice was going to work well, it wasn't worth the investment of time. So I think we did educate some folks, and I think it did do some good, but did it do as much good as it should have? I don't know. So on the next slide, I have one more issue that I want to address, and then I'll wrap up. Karen, can I look at the next slide? Yeah. Recidivism studies were on your list. So Recidivism studies are rare because they cost money. And they cost money for a good reason. It takes an incredible amount of work to sift through the data. There's lots and lots of data, but to sift through it to actually get really reliable figures on recidivism is a lot of work. You need a 3-year window. So what you're looking at, the one that we funded, what we looked at was, so a youth commits an offense in 2025. In the next 3 years, 26, 27, and 28, do they commit another offense? Yes. Are they actually adjudicated for another offense? So you have to have this first you have to have years worth of data, and then you have to go 3 years out from that to look to see. These studies are usually done by the Crime Research Group in Vermont. And if you go on their website, you will see under they have several, not a lot, but they have several studies. We funded one in 2022. We asked them to look at youth ages 18 and 19 who had been adjudicated in the criminal division of non-Big 12 offenses between 2016 and 2019. What we were trying to do was to get a benchmark to look at, okay, here are 18 and 19-year-olds who went through the criminal system. What was their recidivism rate? It will not be surprising to anyone that the recidivism rate for 18 and 19-year-olds going through the criminal division is high. It's almost 46%. Most of the new offenses are committed within the first 6 months after the first offense. Why is it high? Well, you all have talked about one of the big reasons why it's high is what we know about brain development. We're talking about 18, when we're talking about 18, 19, 20, 21-year-olds, we're talking about folks whose brains are not well developed, who tend to be really impulsive and to do bad, stupid things. And so, yes, were the charges all serious charges? I don't know, not necessarily. I think that the report, which is on the Crime Research Group website, and I also have a copy of it. If you want me to have copies made for the committee, I can do that.
We can send it to our the assistant.
Yeah, but there, it's a whole range of charges. We did not use the definition of recidivism that's in statute because that really would not have given us information that would have been helpful. And then there's a whole story about why we have the definition of recidivism that we have. But so we used a different definition of recidivism, which was, were there any actual adjudications, regardless of whether they ended up in jail or not? The one in statute requires some kind of jail sentence. Right. And since that doesn't happen very often in Vermont, it doesn't tell you very much. I think only 1 or 2 of the kids of the 700 cases or whatever, only 1 or 2 of them actually ended up with, on the second offense, getting a jail sentence. But that doesn't really tell you what you want to know. But the question is, does it make a difference to adjudicate cases in the family division versus the criminal division? And we'll only know that if we do another follow-up of the 18-year-olds. And we were really only at the point at which we would have the 3 years of data. In part because of COVID, those years are not good years to use, I think.
So Representative Arsenault has a question.
Judge Davenport, did you say which definition you didn't use for the purpose of this study? What constituted recidivism?
For the purpose of this study, what constituted recidivism was within a 3-year period of the adjudication of the first offense. Was there an adjudicated second offense?
Okay, so adjudication.
Adjudication. No, it's not charge, it's adjudication.
Okay.
Yeah, good point. So I'll let Karen kind of Karen, can you wrap us up here? Because I think we're to that point.
Okay, well, thank you. So as Judge Davenport described, the ways in which the Council for Equitable Youth Justice can partner with the system players is through our small grant funds that we can leverage that allows us to test ideas. And so what she described is that we're testing an idea right now regarding this domestic violence programming. And we have had many successes, and we've also had a number of projects where it was like, we tried that, we're got to try something else. But the point of this is that it really allows us to be a partner with testing approaches, et cetera. So in closing, we strongly believe in recidivism studies over time. The Council for Equitable Youth Justice is currently discussing what time frame we would like to do the next a recidivism study that we funded. We are also, as I shared, we can leverage CEYJ funds to identify gaps, make recommendations, and also implement programming. We also, in our role of continuing to address systemic inequities, we can be a partner in that. And then I think I would just close by saying to always keep in mind that we are talking about children and young people who have specific developmental needs. And one of the reasons that we are so focused on this is that we know that young people desist in criminal behavior over time, and we want to be able to give them a chance to fully participate in our society without a criminal record. So this is the value set that has aligned our council in our work and how we determine what grant projects we undertake. So thank you so much for having us here today. And we wish you the best of luck with the work ahead. And of course, if there are any other questions, we are happy to take those. And I can also stop screen sharing. And I'm noticing that our website is actually not on here, and I'm happy to share that after we finish today.
And I want to thank you also for asking it. My husband asked me, I'm 77 now. My husband asked me, why are you still doing this? I thought you were retired. I do this because, in my experience, both in the legislature, but primarily as a judge, this is the critical place. This is the place that makes a difference, that we can make a difference. Once you get into the criminal system, it's really hard. It's really hard to make a difference in terms of having people go through that system and then go on to lead lives that are that contribute to society in positive ways. If you don't address these issues when they're kids, trying to do that when they're adults is really, really difficult. So I remain pretty committed, I guess, at least for now, on this area.
So a quick question. We're going to be scheduling in a couple of days on specifically raise the age issue next week. Is that something you would wish to weigh in on? You have in the past? We have the April 1st deadline for the next step, but there's been significant pushback on that, and we need to continue to dive into that a little bit. Is that something that you would have something?
The council has taken a position that barring information that we don't have at this point, that we should move on to the next step.
But we'll probably do the next week to expound on that to get a little bit further. So, Representative Stepp.
I'm new. Who actually creates the policy and votes on it? All of legislators?
Yes, it happens in
So we
committee.
bring a prepared policy?
That's what bills are.
No,
The
that's what bills are. See, I need to learn all of this, and don't be shy to help me. because I don't take it as an insult. Anybody, don't be shy. I don't care if you're Democrat, progressive. I really don't care about parties. I want to learn and I want to do what's best for the Vermonters. So don't be shy. I don't take things and I'm 66, I'm past all that.
All right.
Thank you.
Thank you so much, Judge Davenport and Karen Bastine. So we're gonna go, Martha, I have to jump to Laura, who has a hard stop point. Is that what?
Well, I just want to make sure I can testify today, unless you can have me back before the AHS people at 1. Which-
Yeah, let's start with you, and then Marshall will go to you after. So I know I talked to Marshall, it sounds like you might have some availability this afternoon in case we don't get through this right now. Was my understanding correct in our earlier conversation?
Oh, I know.
Okay. All right, so please
I also
don't.
work in this building, so I can always come just back downstairs. I don't have a PowerPoint.
If you identify yourself for the record.
My name is Laura Carter. I am a data analyst in the Division of Racial Justice Statistics, which is a division within the Office of Racial Equity. Okay. I'm actually really excited to be going after Judge Davenport because the majority of our testimony is actually about data and data infrastructure and collection. But first, for those of you who may not be familiar with the division, I just want to give you a little bit of a background. So the Division of Racial Justice Statistics was established by Act 142 in 2022. First page, our purpose is, the mission of the division is to collect and analyze data relating to racial disparities with the intent to center racial equity throughout these efforts. The purpose of the division is to create, promote, and advance a system and structure that provides access to appropriate data and information, ensuring that privacy interests are protected and principles of transparency and accountability are clearly expressed, and the data are to be used to inform policy decisions that work towards the amelioration of the racial disparities across the systems of state government. We were also given a lot of the same questions that the other folks have already presented on, but we were unable to obtain the data in enough time to analyze it for today's presentation. So we look forward to the opportunity to do that potentially sometime in the future. Obviously, this is going to be a big discussion this session. So mostly, I just wanted to kind of address a lot of the things, again, that Judge Davenport brought up in her presentation, as well as stuff that was brought up in testimony yesterday. So based on the notes that I took on yesterday's testimony, there was roughly 20 unique data or data systems concerns and requests made for data by this committee over the course of the day-long testimony. Several questions asked regarding data systems across the board, primarily with a focus on the Department for Children and Families and the judiciary data systems, which, like I said, will be the focus of this. So many of these questions have actually already been outlined and asked by the RDAP committee. They submitted a report in 2020. RDAP is the Racial Disparities in the Criminal and Juvenile Justice Advisory Panel. I will submit a written testimony of this and include links to their report. Yes. In the appendix, you can see they have broken down both the juvenile and the adult systems and their areas of interest in data collection, where those data might actually live now as a state, and where they could be created and or whatever if a new system is established. So I really just want to emphasize that these are conversations that we are going to continue to have. Like I mentioned, the RDAP report was written 5 years ago. And that these current systems cannot always easily query this data. And a lot of work is still manually pulled or done on paper. I know the Commissioner of the Department of Corrections, Nicholas Demmel, mentioned that a lot of their work in the facilities, which I know is the adult system, is done on paper. And a lot of that can be found also in DCF's district offices, and it's not unusual for other departments across the state to still be doing a lot of manual paper-based work. So the office and the division believe in systemic solutions for systemic problems and transformation versus transactional change. So being unable to efficiently and effectively pull accurate and good quality data exacerbates our inability to identify the reality of the gaps that we've all been kind of talking about yesterday and today, and the disparities within our systems to be able to effectively make decisions based on accurate and good quality data. So this includes prioritizations on improving data collection practices. Something that I thought of during Judge Davenport's presentation was switching to calendar year versus fiscal year. This is something that comes up a lot in the crime research group about identifying human trends. It's really easy to like make budgetary decisions on the data if we have it in fiscal year, but what are the trends of these populations when it's in calendar year? I used to work at the Vermont State Archives and Records Administration, and we had accessioned a collection from a former warden in the Department of Corrections, and they had a memo about escape season, right? Like, be careful, escape season is coming. So like things like that, to be able to identify trends in that way that are associated with seasons and times of the year versus like our budgetary mandates. Systems and mandatory data elements have been ongoing discussions but haven't been enacted by policy despite increasing demand for niche data reporting to make data-driven policy decisions. And the work that we do can only be as good as the tools that we are given to do them. And I want to acknowledge something that you said yesterday, Rep. Study, about, DCF can only do as much as they can with the tools that they are given to do them. And I have a quote from a report from the Office of the Child and Youth Family Advocate to share later that acknowledges that. And again, just want to really emphasize that the work that we do and the requests that you are making of the state departments and agencies is only as good as the tools that we have to do that work. Are there any questions yet?
Not yet.
Okay. So from a 2023 report from the Office of the Child, Youth and Family Advocate, this was about the CCWIS, I think it's Child Care Welfare Information System is what that stands for. So this is a quote from the Vermont Citizens Advisory Board in 2021. DCF's data system was launched in the early 1980s. Prior to the launch of the World Wide Web, Vermont has been asking DCF and their family services staff to use 11 disparate and separate systems and over 30 plus Excel spreadsheets to support the work that they are doing and their reporting requirements. We know that this practice is time sensitive, increases the likelihood of human error, and is cumbersome. We also know that the lack of a comprehensive data system that communicates across silos disadvantages us, the children and the youth and the caregivers in our child welfare system. We are currently unable to speak confidently about trends in outcomes for the system that is responsible for the well-being of some of Vermont's most vulnerable children and youth. There is also
a question right here.
Yeah.
Thank you. Yesterday we heard testimony about there's an RFP out, I believe, for that system to be redone and redesigned. And in the testimony we heard yesterday was that the RFP that's out is for the one big gigantic system. And I just wondered, from your expertise and your experience, do you have any thoughts on which is wiser to kind of chunk it out in smaller like modules? So we, because I similarly, like working in state government, by the time you get a data system done, it might already be outdated because it might take like 4 to 5 years. So I just wondered if you had any expertise in any.
I did look into, because part of what I was initially considering for this testimony was I still think that it should happen on a personal level for appropriations to DCF to have more money, to have a system, a more supportive system. I do know they have the RFP out now and that they have received funding in the past. I personally think that it would make more sense to do the whole thing at one time. But someone from the Department for Children and Families probably could address that better based on their former RFP processes for this system. Good. Okay. So the lack of efficient and updated infrastructure means more error and ultimately increases risks and liability for the youth that we're trying to protect, as well as prevents the departments from getting funding or doing their work in a way that isn't overly burdensome to their staff. Like I mentioned, this is a lot of manual work. Even again, in asking the division to respond to the questions that were sent out, in trying to get the information in such a quick turnaround, if we had more effective and efficient systems in place, it is likely that we could have met that deadline. However, that was not the case. I also wanted to bring up that having data governance and a more robust infrastructure paired with information governance is going to be really a key solution to having these kind of conversations as we continue. And yeah, And basically, we need to have continuing conversations about the infrastructure issue and data integration and sharing across agencies. Obviously, as we know, there's a lot of overlaps between these systems, but there are different access points, or certain individuals don't have access to everything that they need. Obviously, there are state statutes and federal mandates in place there to protect some of these information, and that impacts access for the people trying to pull the information. But again, something to think about. I believe last year there was something that came up about a larger integrated criminal data system, but I'm not really sure where that has gone. And then if we, sorry, no, that's okay.
Can you say a little more about what you mean by information governance?
Yeah, so data governance and information governance are like, I would say maybe like cousins or whatever. Together they make everything better. The data governance is really about the process of creation of data and reporting on that data, and the information is about the business value, the efficiency of information technology, and how it is used to propel policy in our business. Is that helpful? I have a chart, which will be part of my write-up. But it addresses 4 big buckets: business, IT, records and information management, and the legal risks of not having a management strategy in place for the data that we want to have in our systems. Is that okay? Cool. Okay. And if we continue to delay addressing the systems issue, we're basically going to be having these same conversations forever. About not having a full picture of where we are failing in the broader scope of juvenile and criminal justice, impacting the lives of youth. And we're even seeing this in our division in upstream factors as well, with other agencies that you may not necessarily consider having an impact. But we have a preschool development grant right now. We have a data analyst that is working on the early education side, and even the Agency of Education systems are really difficult to work with in identifying, again, the youth that we may see further downstream in the juvenile justice system. And this is with exclusionary discipline data, which we did, the division submitted their annual report yesterday, so there's a little bit about the exclusionary discipline data there, as well as hazing, harassment, and bullying data. So there's some incompleteness there. These things are all kind of upstream factors to what lead us into these kids coming into the juvenile justice system. Mm-hmm. So that's really all I had to say. And I'm happy to take questions. And like I said, I will be writing this up and sending it along.
Great. No, I really appreciate that. So we probably in Judiciary Committee are going to have you back in and dig a little deeper on some of the data issues for the criminal justice system, and probably in conjunction with the crime research group. The other thing is, has our new Energy and Technology Committee reached out to you, or have you reached out to it? Because I think we should connect you for those broader systematic or system issues.
Yeah.
To them.
To my knowledge, I'm not sure if they have. I'm actually not the policy person for our office. I was just tapped to testify on this. And after hearing yesterday's testimony, I was really grateful about how much data came up, because that is something that I can definitely speak to, and how our systems could be better. But Angela Lasso Jimenez is our new policy analyst. You guys might see her around the building. So if she has gotten something, I haven't seen it, but she would be the person to reach out to.
Just to make that connection.
Yeah.
That'd be important. Any other questions? Not seeing any. Thank you again, and we'll have you in again, I'm sure.
Thank you.
Marcia, if we can have you back, and
Yes.
well, I'm going to assume that you've been patient.
He's appeared to be patient.
Yeah. Well, Marshall, we've been dealing with for years.
Yeah,
He's very patient.
Like screen share?
Yep, you're all set. I just made your calls. Thanks.
So I'm gonna pick up right where everybody else left off. Because, let me get rid of these. All right. Because my next question to address was what data is available. And my sort of tongue-in-cheek answer is very little. But my more realistic answer is this, is we actually have a lot of data. we don't actually have a lot of useful or meaningful data. And the thing that I think has already been brought up by Judge Davenport, but it was my first bullet point that I wanted to make sure that people saw, is we don't have recidivism data, which is probably the data we want the most. That's probably the data that is the most valuable for figuring out what parts of our system are working, what parts of our system are not working, what parts of our system can we tune up, what parts of our system are we just simply are underutilized. All of that is really going to come from recidivism data. That's what we want. Now, I also want to make clear that recidivism is only one piece of the equation. It's what's looked at the most often. I don't actually consider it the most important measure of whether the system is working. If I have a client who ages, yes.
I apologize.
Is recidivism data available for any cases that go through family court?
No.
So no matter what we do, we're gonna have incomplete information.
In order to get recidivism data, we got to do a recidivism study, which, as Judge Davenport said, is expensive. It really does require sitting there and going through individual by individual and tracking names. Our office does not have the resources to do it.
Right.
I'm not sure who in state government does. In the past, it's always been something that's been contracted out.
But even with a study, we won't have the information for family court.
Well, so here's what I'd actually say about it. Right now would be a bad time to do a study because recidivism is defined by a term of years. In Vermont, we use 3 years. Committing a new offense within 3 years is considered recidivism. Going 3 years without committing a new offense is considered desistance. And so if we looked back now, we would be capturing a whole bunch of the pandemic period, which might be really interesting data, but it's not really meaningful in terms of planning. What do we do and how do we go forward? Because the pandemic was all of us pulling ourselves up by our own bootstraps, changing processes, changing systems to make them work as best as we could given the circumstances that we had. And it's not reflective of practice prior to the pandemic, nor practice post-pandemic. It's really its own little window. So really, I think the right time for a recidivism study is 3 years after we've escaped the sort of tail end of the pandemic that's still kind of clinging to our court systems. Not so much to the juvenile system, but to the criminal system in particular. But that does make me, look, I want to talk about recidivism because from my perspective, it's not really the indicator of success or failure that people make it out to be. You know, for example, if I have a client who, like 70% of my clients do, has had some involvement in the child welfare system, meaning they've at least been suspected of having been abused or neglected as children, who then wind up in the juvenile justice system, very typical. The juvenile justice system involved youth have child welfare histories. And maybe they're in the juvenile justice system for something pretty serious, an aggravated assault. And then if, a couple of years later, they're 20 years old, and I represent them in a new charge, and it's a DUI, and I meet with them at their arraignment, and they have a job, they have a family starting, they got a house, and yeah, they got a DUI. I still consider them a success. I mean, that's a kid who came out of a really tough place, came out of a juvenile justice system that often does not lead kids to places of success, and managed to start really sort of building the foundations of success in their community. And the fact that they got a DUI, to me, is not a sign of failure. That happens to some people sometimes. So I don't like to look at recidivism as my marker of success. I want us to be keeping track of things like educational attainment, job training, employment. One of the studies from Ohio that I thought was really good, where they found a way to do not a recidivism study, but a sort of positive outcome study based entirely on public data, was to look at they took their old juvenile court records and they matched them up against tax filings. And their only question was, 5 years after they've aged out of the juvenile system, is this person a taxpayer? And that was a way, it's not really a great indicator of success because there's all kinds of ways to achieve success without necessarily, joining the economy in that way. But it's a real indicator of success. I mean, if somebody's filing a tax return, that means they've got a job that pays enough to warrant filing a tax return. And that's a basis, that's a real foundation for building something up. So we want to see outcome data that looks at everything. We want to see educational completion, employment, housing, any other measure of success and satisfaction we can find, because we want to see what works and what doesn't. Right now, we lack the ability to look at granular data. Everything we see is in the aggregate. And that means that we can't tell what portions of our system work and what don't. And that's where I have sort of a tongue-in-cheek, we should be in the StatCast era. I don't know how many people here are baseball fans, but if you watch a baseball game, they can just pull up, a manager can just whip out an iPad and be like, I want to know what percentage of the time this player is going to get hits from pitches in the zone, up and away, from left-handed hitters, at home, from, on, sunny days. And they can look up all of that. I want to be able to do that. I want to be able to say, how successful are kids that are represented by this attorney to go through this program and that finish with this result. I want to be able to say, let's look at all of the programs and see which ones are turning out kids who are successful and which ones are turning kids further into the deep end. To me, it is outrageous. And this is not, I want to say, a Vermont problem. Crime data sucks nationwide. The best data that's out there is the FBI's NIBRS data, and even it is so bad, it's considered unusable by pretty much any data scientist. Less than 50%, that's based on law enforcement reporting, less than 50% of law enforcement agencies report to NIBRS, and the ones that don't tend to be the biggest agencies. So like in New York State, a lot of New York State reports to NIBRS, but how good is that data when New York City does it? It's most of what happens in New York State happens in New York City. New York City doesn't report their data. So when you see New York data in the NIBRS, you're just seeing upstate New York. And only then you're seeing those agencies that choose to submit their data and not those that don't. So we have a nationwide problem with terrible crime data. And it's crazy that I can't just punch up crime data the same way that baseball managers can punch up baseball statistics. And if we could, our system would look so much different. We would be able to granularly say, which judges are really successful? Do we have judges that are identifying the right kids, the right cases, the right placements, and making all the right decisions? And do we have judges that are making all the wrong decisions? Do we have attorneys that are just failing at every case, that are really just not doing a good job advocating for good results? We'd be able to see that. We'd be able to see, does this program work, or is this program always steering kids into the deeper end of the system? We'd be able to see whether certain, how are our diversion programs working? How are our barge programs working? See it county by county, even see it worker by worker. We love that. If we had that, we would use it constantly. We love data, we love to use data, but it's not available. So,
Representative Cole?
Thank you. Just out of curiosity, though our country is kind of unique in the way we handle criminal justice in some ways, in many ways, are there other countries that have done a good job with data tracking and specificities?
Yes. I can't tell you which ones, but at the bottom of that page, I linked to a blog that's written by a data analyst who focuses on public policy and crime. And it's actually from him that I got the whole StatCast idea. And I read his blog and I was like, that's right, why don't I have this? Why don't I have access to this? Like, why does this exist in pro sports, not in criminal justice? He has some good sections on international crime reporting and where it's being done well and where it's not.
Where did you say that was?
It's a link that's on the bottom of the slide that I just showed, which is on the Judiciary's documents page.
Well, thank you.
So the next question was to address how is youthful offender status different from juvenile court? And The answer is they are totally different. They're just two completely different things. Youthful offender status is actually an adult status. It originates with adult court eligibility, and at the end of the line, if you screw up and get your status revoked, it results in adult court sentencing. And because of that, it is an adult court process. All of the rights that adults have attached to this process. In juvenile court, everything is confidential. In youthful offender cases, there are parts of it that are specifically not confidential, that are held in public. In juvenile court, children are supervised by DCF and cannot be held in DOC facilities. In YO cases, youth can be supervised by DCF and DOC, and absolutely can and are held in adult facilities if they violate their probation. If you violate juvenile probation conditions, you can be held in juvenile detention for as long as DCF can supervise you, but you eventually age out. That's the difference. In youthful offender, if you screw up that badly, you're going to be revoked, and then you'll be sent to the criminal court for sentencing. We consider it a high stakes, high reward status. I will tell you that it is a status that is without a doubt most beneficial to kids who have good community supports and not terribly beneficial to kids who don't. What I mean by that is, as a criminal attorney, when I am representing somebody in the criminal court, my goal in most cases is to reduce their exposure to sentencing as much as possible. We do that often by plea bargaining. We sit there with the client, and if it does not look like it's a case where we're going to be able to win by going to trial, then what we're going to be doing is we're going to be working with the prosecutor to say, hey, let's come up with a sentence for this client that makes sense. Let's come up with a sentence that's going to protect everybody that needs protecting, but also benefit my client. And we work towards some kind of a goal like that. You don't have that option in youthful offender cases. In youthful offender cases, it's like going to trial and losing. If you get your youthful offender probation revoked, you are sent to what's called an open sentencing, meaning the judge can sentence you to any sentence that's within the range of sentences prescribed in statute. So you've totally failed to do what you try to do as a lawyer, which is limit your client, as a defense lawyer, which is limit your client's exposure to harsh sentences. So for that reason, I look at youthful offender as being a good status for kids youth who are good supervisees, and a bad choice for kids who are not going to be good supervisees. And so for example, if I have a young person who has supportive parents and an educational plan in place and has the resources to engage in all of the things that DCF might want, therapy, treatment programs, substance use assessments, all of that, and have parents that are supporting them and trying to encourage that process to happen successfully, then I'm going to encourage that client to file a youthful offender petition, because that's where they're going to see the best outcome. If I have a client that's living on their own at a young age, like a lot of us did, doesn't have family support, doesn't have, a really established social network of support that can help them in these kind of really vulnerable situations, I'm probably going to tell my client, youthful offender may not be the best outcome for you. You're probably going to be better off with an adult deferred sentence, because that'll allow us to negotiate around sentencing if it comes to that, because those resources and that support really are critical to success as a youthful offender. All of these probation conditions require you to jump through a lot of hoops, and I shouldn't call it jumping through hoops because that trivializes it. It's important things, but it's a lot of steps. It's a lot of making sure that you do the mental health assessments that they want and follow the recommendations, the substance abuse assessments they want and follow the recommendations, the educational requirements, the job training requirements, just the everyday sort of management requirements of letting your probate, making sure you attend every appointment and making sure you, show up at every place when you're supposed to be there, at the time you're supposed to be there. So,
So can you just describe it, you said the alternative adult deferred sentence, can you just describe that a little more?
sure, so a deferred sentence is similar to, it's actually very similar to youthful offender, but with two significant differences. One is that none of it takes place in confidential setting. It is a public setting situation. And the other main difference is that if you violate your terms of probation in a deferred adjudication or a deferred sentencing agreement, you can already have pre-agreed to a plea agreement with the prosecutor. Whereas in a youthful offender case, there's no plea agreements that are pre-set, and so you go into an open sentencing.
So the deferred sentence is that if you do all these things, these conditions for the next 2 years, you're not gonna get sentenced if you're successful. That's essentially
Yes.
what that is, okay.
Yeah.
And is there a piece around what is on your record as well?
Yes, so during a deferred sentence, the charge is on your record during the pendency of the deferred, and then if you successfully complete it, then it's expunged. And if you fail to successfully complete it, then you are sentenced and it's permanently on your record. And the same is more or less true of a youthful offender case. If you are successful and you complete youthful offender probation, then you get that expunged. But if you are unsuccessful, then you are sentenced and it is a permanent part of an adult criminal record.
I think that's an important piece that makes it similar to that, because having it expunged and just not easily accessible is important.
Representative Burger, then
Yes,
Representative Garcia.
expunging that would taint any recidivism studies.
If it is expunged in a way that we can't access it for recidivism studies, our current expungement statute requires the court to keep an index of essentially the basic information from each case so that it can be accessed by researchers under a memorandum of understanding with the judiciary.
Did we have some expungement that completely seals?
I think back in
That's what's on my mind.
There's a while where we did have that. Everybody was, like, our office was opposed to that because it caused us problems, especially for people who were non-citizens who need to be able to, if they get charged with something, they need to be able to have access to all the documentation to prove what the outcome of the case is if they're looking to either get citizenship or adjust an immigration status. So there was a period where there was too much actual disposal of documents going on. And that was corrected, I want to say 10 years ago, to keep this index, which can be used for all of those immigration purposes, federal background checks, federal governmental background checks, a few other things that come up where those are really important to have.
Thank you.
I'm wondering, based on what you just said, Marshall, about the high risk, high reward of youthful offender status, and that it is sort of sounds like in some ways a test of executive functioning skills. Do you see in your practice disparities, economic disparities? It seems like it's baked in.
Absolutely. But I mean, I think that's true of the entire criminal justice and juvenile justice system from bottom to top. From the very beginning of who I see walking into court, I see economic disparity. And yeah, if you have a lot of money, you have a lot more chances to be successful because you have access to resources, access to supports, and access to supportive services that other people don't have.
So, that being true, is there anything, maybe apart from more money, that prevents us from supporting us as a state, like offering those supports to folks to youth who have chosen youthful offender status, who don't have them, thanks to family resources or something?
We can always do better. We can never erase the disparity. I mean, I have clients who have gotten youthful offender status and been tremendously successful, and sometimes it's because they've been able to go to college, which provides them with all the structure and support they need. And that's because they were clients who had wealthy parents who could afford to send them to college, and I have clients who aren't in that situation and don't have access to that. There's always going to be a disparity. The more money and the more sort of concerted effort we put in to trying to achieve equity, the better off we'll be. Do I think that there's something we could do to achieve equity? No, I don't think that's possible.
But we could do better.
Sure, yeah.
Representative Goodall.
Just a really quick question. On the exposure for the youthful offender deferred adjudication, do you see in your practice judges during like the proffer at the end, like when they're doing the adjudication, kind of explaining that exposure to the defendant or the, I don't know what the term is for, so that they understand, or is it more on the attorney who's negotiating with the prosecutor to explain to their client that exposure and whether to take it, which you clearly are doing, which is great, but I'm just curious.
I've seen both.
Yeah.
I've seen judges who engage in a really extensive colloquy that definitely includes a real hard sort of like, you understand, if you screw up, this is the consequence, and this is what it looks like. And I've also seen judges who kind of breeze through it real quickly and don't engage in much colloquy beyond sort of the bare minimum Rule 11 that you gotta do.
Yeah.
Finally, I just wanted to sort of leave a couple of thoughts on the table, which are that our juvenile justice system, despite our lack of recidivism data, we know that our juvenile justice system is better for youth than our criminal justice system is. And we know that because we can look at national data that does show that our justice systems are successful with young people when they're able to work without delay. Delay is the enemy of justice everywhere, but in particular with youth. You have to, it's always so upsetting to me when I have clients, young people who are cited into court 3 months out, they do something and they're handed a citation that says come to court in 3 months. By 3 months after the incident has happened, you've already lost any chance to really connect or engage with that kid about what happened. It's the speed of the system that makes the system effective. And the juvenile court system works a lot faster than the criminal court system, especially now, especially after the backlog. Part of that's because the juvenile court system kept running through the backlog. We kept having hearings by video. We kept the juvenile courts going, with the exception of a handful of merits hearings that had to be postponed. We kept the juvenile court system running, where the criminal court system had ground to a halt. So we're still dealing with pandemic backlogs in the criminal system that don't exist in the juvenile system. And that means that it's a lot easier to get a young person into family court for an arraignment immediately after they've been charged with committing some sort of an offense than it is to get an adult in. And when you get an adult in, we're usually going in and getting arraigned and then setting it for a status conference or a calendar call 3 months out. In the juvenile court system, things move much faster. I'm not gonna say they move as fast as they should. I'm not gonna say that we keep up with the timeframes that you heard about yesterday that are in statute. We definitely don't, but we do better than the adult system in terms of getting the case started early, moving through it quickly, and reaching a conclusion pretty quickly. And that's one of the things that makes the juvenile court system way better for youth than the adult court system. In the adult court system, delay is the name of the game right now. And that's especially true for the more minor offenses. It seems kind of backwards that like the minor stuff would be more delayed, but it's a matter of priorities. The courts are obviously hearing the cases with serious offenses and people who are incarcerated first. And that means that the more minor stuff, which is the majority of offenses committed by kids, is on the back burner. So, our misdemeanors right now are taking longer than felonies in a lot of cases because they generally don't involve somebody who's incarcerated awaiting trial, and they don't involve, serious harm to victims who are kind of, encouraging the court to move quicker. So from my perspective, the more that we serve youth in the juvenile court system, the better off we are as far as the timing of it goes. I also want to say that the most concerning criminal conduct we're experiencing is not being driven by young offenders right now, which is really interesting. This is a shift that's happened since the 70s. If you go back and start looking at data for crime rates, violent crime and property crime, both violent interpersonal crime and property crime, both peak in sort of the early 90s. And there was a really traumatic increase in the 90s in youth crime. And it was all crime that was wrapped up around drug use, at the time largely crack cocaine, and violence. Since then, we've been seeing a constant decrease in youth crime. And what's remarkable is that decrease has been backed up by a lot of sort of collateral data that's not even related to the criminal justice system. Young people today are just simply behaving better than young people when I was a kid. There is less use of nicotine products by young people, less use of drugs by young people. Even right now, even in Vermont, even where we have a crisis of fentanyl use, we're actually seeing decreases in opioid use by young people. It's really being driven by an older population, sort of mid to later 20s, that are the heavy fentanyl users in Vermont. Lower teen pregnancies than we've ever had before. Lower counts, higher educational achievement than we've ever had before. Kids today are actually really, really well behaved, to the point where some social psychologists are actually concerned that children are not engaging in enough risk-taking behavior to sort of, to learn through the process of adolescence. As an adolescent, you're supposed to engage in risky behavior. It's part of your brain development, is to test the limits and to do that. And it's not just us. All mammals engage in the same adolescent behavior. Adolescent gazelles play tricks with lions. They'll run up at lions and get them to chase them and then run away. And sometimes they get caught, but they do it anyway because it's what you do when you're an adolescent. They're showing off for mates and trying to impress their community. It's built in. But the stuff that's most concerning to us, which, from my perspective, is the drug use and the violence. That's not youth-driven crime right now. It used to be that youth really drove drug use, and that's changing. It's really an older cohort driving drug use right now, and the same is largely true of violence. I do want to leave two little exclusions to that, two carve-outs where I will say, yeah, there is some youth-driven crime. One is car thefts. Car thefts went through the roof in Vermont, and it's completely TikTok related, and it's kids doing it. And it's because there is on TikTok now, there is just this wave of videos of children all over the country stealing cars, showing kids how to steal cars and doing it with relative impunity. And that has just sparked all over the country. It kind of hit us last. I was hearing from my colleagues in Connecticut about the crazy car theft problems they were having, and I was laughing about it like, that sounds crazy, what are you talking about? And then it hit us. We got it last, but it's a nationwide issue. And then I do think that it's absolutely worth acknowledging that with the increase in drug use in Vermont, opioid use in particular, we've seen what I would say is a proportional increase in youth involvement in it. There's always been young people involved in the drug trade. When I started out in practice, we'd never heard of fentanyl. At the time, it was oxys, it was the pills. And they were arresting young people coming up from New York with oxy pills. And everybody was saying, oh, God, they're targeting, they're using young people in this trafficking situation because they know that Vermont's got lax juvenile laws. At the time, our laws were far more harsh than New York's laws. It's not the laws that change whether or not young people are involved in the drug trade. young people are always involved in the drug trade and always have been involved in the drug trade. So as we've seen the drug trade in Vermont expand, we have seen more young people involved in the drug trade coming into our justice system. I would say that it's proportional with the expansion of the drug trade. You know, back when I was doing it, it was a few kids here and there trafficking OxyContin from New York. Now it's more frequent, and it's usually kids bringing up fentanyl from Massachusetts. So it's changed in terms of where it's coming from and what it is, but I would say it's approximately the same amount given the expansion of drug use and trafficking.
So those particular cases, how often are they under the new big 11 plus three, having a firearm and along with
Not seeing many with firearms. I am seeing lots of drug trafficking charges.
which also are a big 14, right?
Yes, and so those are typically getting pulled into the criminal court, which, for what it's worth, does mean, you know, if you just Google, you can see how many there are out there. There's not a ton. When you're looking for people 19 or under, who are, you know, under 19, who are being charged with drug trafficking, it's a pretty limited number, but it's more than we've seen in the past years. So I thought it was worth bringing up because it is a significant increase. It's still a small number.
Last question to Representative Arsenault, and then.
It's more of a statement. I think it's more of a statement. First, well,
Just add the question then. Do you
yeah,
agree?
I don't know, I don't know, I just feel like I have to say, as someone who's really invested in youth mental health, that kids might be behaving better, but they're more likely suffering in
Right.
silence and in their bedrooms, on their phones, depressed and suicidal. And so I just don't want to put in anyone's mind the idea that like things are hunky-dory for kids right now, and a lot of the problems are showing up in schools rather than courts.
Yes, thank you, I was thinking the same thing, you articulated what I was doing, so I appreciate that. So we're adjourned, offline.